given that on December 17th, it's actually the third anniversary of the first judgment delivered by the European Court of Human Rights, 2013. So
Yes.
3 years after the initial judgment, there are a number of different perspectives in Armenia, across Europe, in Turkey, about the legacy of the Perincek judgment as delivered by the Grand Chamber.
Okay.
Partly corrected, but partly remaining the same. So what do you think is the legacy of Perincek judgment?
I think that we bring too much attention on the Perincek case because the European Court of Human Rights didn't make a decision on principles. They have just made a decision about this specific case. And there are a few proofs about that. First of all, as they have very clearly stated in the judgment, the Grand Chamber judgment, they didn't take the role of assessing or qualifying the events that Perincek was denying as being a genocide. They just withdraw from this debate. And from what I have read, from the different briefs submitted by governments of France, of Switzerland, of Turkey, none of these governments was willing to bring this debate at the European Court of Human Rights, because this is not its mission. This is not within the scope of the European Convention. The European Court of Human Rights is not an international criminal court. They have nothing to do with this. However, they could have considered the international criminal law to better qualify the denial, the way Perincek put it. So I will come back to this. Why did we Armenians, so Armenian government or Armenian in diaspora, put so much stress on this issue? And here you have different views. You have the views of most of the Armenians in diaspora who had, but also in Armenia, who had a very emotional vision of this speech of Perincek. So putting too much stress on what he said, the reason why he said that, so the meaning. While I have adopted from the very beginning a more strategic view. Why was it important for Armenians to not let the decision of the law chamber as it was? Because in the law chamber decision of 17 December 2013, there was a reconsideration by the court of the historical and political consensus about the reality of the Armenian genocide, which was absolutely not acceptable. The court had gone much beyond their role and mission. And based on very ridiculous arguments, like saying only 25 countries in the world have recognized the genocide. So this was really ridiculous, but this was very dangerous for Armenians, because this decision was challenging the historical and political reality. So, and
decision as delivered by the lower chamber.
By the lower chamber. And in that respect, the decision of the Grand Chamber on 15 October 2015 is a correction, a rectification of what has been done. Because not only they didn't want to enter that debate, recognizing that it was not their role, but they even said that this debate is open for future judicial courts, and this debate, they even recognize that it was in the power of a Swiss tribunal to consider these historical facts as a genocide. They didn't challenge this decision of a Swiss tribunals. The only thing they challenged is the disproportionate sanction against Perincek by the Swiss tribunals in relation with the nature of violation. So they consider that the nature of a speech, the meaning they provided to the speech, didn't deserve a criminal sanction. That's very important for Armenians to understand. So the European Court didn't condemn the Swiss assessment of the historical facts, which according to the Swiss courts are constitutive of a genocide. So that means that this is to some extent a victory for Armenians. That's the first one. The second victory is that in the judgment, if you look at the judgment very thoroughly, the European judges are saying quite clearly that the reality of the massacres and deportation is not challenged. Not only they say that, they also say that Turkey does not deny the reality of these massacres and deportation, neither Perincek. So what was the discussion about? The whole discussion was about the intention and the meaning of the words used by Perincek. And here, the European judges have played a very mini and nasty role. In the law chamber, Perincek was considered as having delivered a speech as a historian, jurist, and politician. That was, in fact, attackable. And in order to deliver Perincek from a sanction, they have completely reinterpreted, first of all, the profile of Perincek and the content of and the meaning of his speech. What did they do? They said, since Perincek has come in Switzerland to deliver a speech in political meetings, public meetings, we have to consider that Perincek was there as a politician and not as a historian or jurist. Why is it important? Because as a historian or jurist, he was subjected to a scientific demonstration that the Armenian genocide was not a genocide. There is a repeated, recurrent jurisprudence of a European court about this. If you are a scientific person and you deny the Holocaust, then you have to bring all the antithesis arguments and not bring only your thesis. So that was to qualify him as a politician during that speech, so prevented the court to condemn him. The second aspect is about the meaning. And here, this is really a very incorrect decision from the European judges because they considered that the meaning of a speech of Perincek was not aiming at the Armenians, but was aiming at the imperialist powers. And this is a pure invention. I mean, when you say, as he said, the Armenian genocide is an international lie, it is very obvious that he is aiming at the Armenians, because those are the Armenians who are stating permanently and claiming everywhere that it is an Armenian genocide. What do the imperialist powers are doing in this stuff? I mean,
so what was the objective of Perincek's speech?
well, we all know the background of Perincek. This was not the first time that he was delivering such a speech. It is obvious that he's challenging the Armenians. And of course, he is now arguing that he was just challenging the legal qualification of the massacres and deportations against Armenians. But at the time he delivered this speech, there was no judgment of the International Court of Justice which could justify that approach. So just would like to open a bracket here. In fact, the International Court of Justice in February 2015 has decided about its doctrine related to the Convention on Prevention and Repression of Crime of Genocide. And they have decided that this convention is definitely not retroactive. But it was in February 2015. So it's quite easy then for Perincek to argue afterwards that he was meaning that.
And to correct the record, since there are many views on the judgment of the Grand Chamber delivered on this case, after all, at the end of the day, did the court say that the massacre suffered by the Armenian people amounted to genocide, or the court denied the truthfulness of these allegations, or the court didn't discuss this at all?
So
what do we take from it?
Yeah, so there are many elements here in the judgment, but also in the dissent opinions of a judgment. So, as I told you from the very beginning, they didn't want to discuss the issue on a legal aspect. There is one very interesting paragraph of the judgment. The court recognized that the genocide is an constitutive element of the identity of Armenians. And this perception by Armenians then confers a right to dignity toward the Armenians. When they declare this in this paragraph, they, to some extent, they recognize the genocide, because they say quite clearly that it is a component of the identity of Armenians. So without coming into the debate on the legal qualification, they consider then that those facts are a reality. The dissent opinion of the 7 judges is even more clear, because they clearly say, for us, the historical facts, the massacres and deportations against the Armenians in the Ottoman Empire are very obviously an undeniable genocide. So here, the massacres and deportations suffered by the Armenian people constituted genocide is self-evident. So, of course, the majority has used a very mildy expression, but here the dissent opinion is very direct. And to deny it is to deny the obvious. But that is not the question here. So the case is not about the historical truth or the legal characterization of the events of 1915. The real issue at stake here is whether it is possible for a state, without overstepping its margin of appreciation, to make it a criminal offense. So you see, everything is set here. So the core issue of the Perincek case was absolutely not related to the Armenian genocide itself. It was just to try to determine where is the threshold in the freedom of expression when it relates to denying such international crimes. In other words, the decision that they have adopted is without prejudice for the conventionality of all the domestic laws that exist or may exist in the future for criminalizing the denial of such crimes.
And the Grand Chamber didn't didn't pronounce actually that the Swiss article in the penal code is illegal.
No, absolutely not. No. That's why the Swiss government is quite happy, because the law remains as it is and it has not been challenged. Only the application of this law will require in the future more attention and more conditions. The conditions have been declared in this case. First of all, it should be a clear incitement to hatred and violence. And secondly, and this is more arguable, I will tell you why, there was no threat to the public order of Switzerland when the speech has been delivered. The European Court made a very strange reasoning. They said there was no threat to public order in Switzerland because there are not potential conflicts between Armenians and Turks. While in some countries where the Armenian community is much numerous, like in France, there may be some ground to be more so accurate and to criminalize such speeches. And here I would like to say that despite a few amicus curiae, so some briefs which have been brought there, the European Court has decided to disconnect the international criminal law from the European Convention. And they made a very arguable reasoning, because what happened to the Armenians is heavy violations of human rights law. The international human rights law is applicable to every state in whatever circumstances. This is what we call erga omnes obligations. And it could have been argued that the denial of such crimes, especially jus cogens crimes, I mean, which have a peremptory norm, cannot escape a link with the international criminal law. So why do international crimes, so answering to the peremptory norms, couldn't be considered also as a legal ground for criminalizing the denial. They avoided this connection in the reasoning. To be frank with you, I do believe that the decision which has been made is a political compromise between states. I have a few indices for that. And because finally the court did not consider all the principled briefs that have been submitted to them. They have just tried to satisfy all the governments, so without trying to make a principled decision. The Armenian government adopted a strategic vision of the case. The most important for the Armenian government was not to go into the debate about the freedom of expression and limits to this freedom of expression. The main objective of the Armenian government was to rectify the law chamber decision, which was challenging the reality of massacres and deportations. And in that respect, they gained the victory. This was also my main concern. But we could have obtained much more.
What does this judgment tell us about the possibilities of adoption of a law on criminalizing the denial of genocides, including the Armenian genocide, in France?
The French frame is totally different, but actually this European Court decision has reinforced the opponents to such a law. Actually, this court decision has helped the Jewish communities to protect forever the denial, from the denial of the Holocaust. In the European Court decision, the Grand Chamber decision makes a clear difference between the denial of Holocaust and all other denials, stating that denial of Holocaust amounts to anti-Semitism. And they don't make any exception. It's a lack of an automatism. Denial of Holocaust should be tried and condemned as incitement to hatred, because this lie on anti-Semitism. And early this year in Paris, the Constitutional Council, so the equivalent of Constitutional Court of Armenia, made a decision in a very important case. One denialist of the Holocaust has challenged the constitutionality of the existing article which criminalizes the denialist of the Holocaust. Saying what? He said, why a citizen in France can be tried and condemned for denying the Holocaust, while another citizen denying the Armenian genocide, for an example, cannot be condemned. So he challenged the Constitutional Court on the principle of equality of the citizens before the law. And in fact, the question was very relevant. Unfortunately, the Armenian organization didn't catch the importance of this case and send all the good lawyers to defend, in fact, this appreciation of the principle of equality. And the result is that, well, the Constitutional Court reused the decision of the European Court to consolidate its doctrine. And That means that there is now a clear double standard established by the Constitutional Court between the Holocaust and the other crimes. I personally consider that those laws, I mean, trying to criminalize the denial of genocide, are useless. They are representing a very defensive strategy on behalf of the Armenians. This is like we are always trying to justify that yes, we have been subjected to genocide. But why? I mean, we don't have to prove anything. This is a historical and political fact which is recognized by everybody, every serious scientific person.
As the dissenting judges confirm.
Yeah, of course. And we are losing time, we are losing energy, we are losing money in trying to get this, while these kind of laws are clearly not appreciated by the public opinion in democratic countries, because they are tired of more and more restrictions to the freedom of expression. So this community driven so actions are actually counterproductive, not only for the Armenian cause, but also toward the public opinions of the countries where we live. That's why most of my focus is to step over this kind of consideration and go for offensive strategy and claim now the repression process for the Armenian genocide. Because we don't need any qualification there. And so irrespective of the qualification of a crime, we have titles and rights to prevail in that case. So this is a defensive, reactive, losing strategy.
What, in your reading, would be the winning strategy in this case?
The strategy is dual. Every single Armenian or every single Armenian institution, like the Catholic State, who have their deeds, property deeds, they should go in Turkey and file cases in domestic courts. There are some openings from the judicial system in Turkey. The other aspect of a strategy, so the other aspect of a strategy is the collective claim. The collective claim relates to the reparation and of the harms committed on the Armenian people as a whole, on all the Armenian assets. So this is a quite different subject, which requires a very sophisticated strategy, legal strategy, judicial strategy, and this strategy should be unique. That means that none of the individual claims, be they legal person or natural person, should provoke some prejudices on the collective claim. That's very important. And
what would be your advice of more welcome strategies to pursue in the European context? And in this context, when do you think the genocide as such will end? Because the historians, the genocide scholars, argued that there are several stages of genocide and denial is actually the last one.
Let's look at the reality today. You have hate speeches by the higher levels of governing people in Turkey. Just the last 2 weeks, President Erdogan, Vice Prime Minister, have had very condemnable speeches against the Armenians. By the way, this brave member of a parliament, Garo Paylan, has decided to sue them. But this can be generalized because when you have a hate speech at state level, at the higher layers of the state, then that means that you are influencing the opinions of your population. And this is not acceptable. And this is in the direction where we should work on the hate speech. There are numerous reports from the Committee on Elimination of Racial Discrimination, or the equivalent body of the Council of Europe, where they denounce all those hate speeches. And it becomes even more dramatic when you consider the hate speech by Azerbaijan, because Azerbaijan is also involving in this denial of a genocide, while they were not, related to that. And this shows that the denial of the Armenian genocide is a clear component of a policy of hatred against Armenians. So we have to make the link between this, and we can prove it today. We can prove it because that hate policy has also some effects on the Nagorno-Karabakh. As you have probably seen, yesterday the Ombudsman of Karabakh has issued a report about the crimes of war committed by Azeri in April this year. And the way they have tortured and mutilated our Armenian people shows that this is a real policy of hatred, and all is linked. All is linked. The major actors of a denialism in Europe, and probably in the US, are financed by Azerbaijan, not any longer by Turkey. There are many historians who have elaborated about this theory, that the denial is the continuation of a crime. My opinion as a lawyer, and which is now becoming also an idea which is also considered by other lawyers, is that the denial of such international crimes should be considered as a crime by itself, as a new crime, for the reasons I explained before. I mean, since these international crimes, I mean, I'm talking about the serious international crimes, which are considered a jus cogens, so totally prohibited. So we have, in fact, to protect also the people who have been victims of those crimes from the denial. So we have to link this to new norms of international law and make the denial a new crime.
I cannot skip this question about Nagorno-Karabakh since you raised it yourself. Do you think that the crimes carried out during the military offensive against the people of Nagorno-Karabakh in April may eventually become subject of judicial procedures elsewhere, in the European Court, in the International Court of Justice?
So here you have different avenues opened. First of all, neither Armenia nor Azerbaijan are party to the Statute of Rome, so we don't have access to the International Criminal Court. But those crimes are clearly crimes of war. And we may, in fact, at least find a legal forum where to make state by international bodies that these are crimes of war. Now, to complete this, I do believe that we should demonstrate that that kind of crimes, the way they have been committed, first of all, they are UNESCO against crimes. And the reasons why such crimes are committed by Azeri soldiers are precisely the official hate policy of Azerbaijan toward the Armenians. So we have, in fact, to file an interstate claim against Azerbaijan, and every state has the right to put such a claim. So ICJ will not take such a case unless this is a very massive human rights violations.
Thank you. Thank you very much.
No mention.